Judge, I believe we're ready to go.
All right, then, good morning, everybody. This is Gloucester Salem. Detention motions. It appears I have in the booth a matter that was heard yesterday, but which I did not decide, even though from a historical standpoint, we would generally start with Salem first because Salem only has one matter. I'm going to go ahead and move to that matter. And that is State of New Jersey versus Ashley Fisler is complaint warrant 2026-221-0818. Counsel, your appearances, please.
Alec Gutierrez on behalf of the state.
Good morning, Your Honor. Rocco Cipriano on behalf of Ms. Fisler.
All right. This matter is before the court on the state's application to detain the defendant. By way of background, I think I need to at least place onto the record the framework from within which we are working. Specifically, the Criminal Justice Reform Act, which is 2A 162-15, shall be liberally construed to effectuate the purpose of primarily relying upon pretrial release by non-monetary means to reasonably assure that a defendant will appear in court when required, will not endanger the safety of any other person or the community, will not obstruct or attempt to obstruct the criminal justice process. The Act provides that following the issuance of a complaint warrant, a defendant shall be temporarily detained to allow the pretrial services program to prepare a risk assessment with a recommendation on conditions of release. And thereafter, the Act authorizes trial courts upon motion of a prosecutor to order a defendant detained on a pretrial basis when it finds clear and convincing evidence that no conditions or combination of conditions can reasonably assure the effectuation of the goals of safeguarding against danger, flight, and obstruction. When considering a prosecutor's detention motion, trial courts must consider the risk assessment, commonly known as the public safety assessment, and the recommendations, and make a pretrial release decision within 48 hours of the defendant's commitment to the jail. To make that decision, the court has to hold a hearing, which we did yesterday, to determine whether any amount of monetary or non-monetary conditions or a combination thereof will reasonably assure that three goals set forth above are met. If the prosecutor moves for detention where there is no indictment, the prosecutor must first establish at the hearing the probable cause exists that the defendant committed the charged offenses. In this case, I found probable cause. Unless the defendant is charged with murder or crime for which he would be subject to an ordinary or extended life term, the Act imposes a presumption against pretrial detention. The state can rebut that presumption of release by presenting clear and convincing evidence. At a pretrial detention hearing, the defendant has the right to testify, to present witnesses, to cross-examine witnesses who appear at the hearing, and to present information by proffer or otherwise. And the state does not have to present a live witness at the detention hearing, but it has the option to do so. Additionally, the trial courts have the discretion to require testimony if it's dissatisfied with the state's proffer. Now, at that hearing, which we conducted yesterday, the court may take into account various factors, including the nature and circumstance of the offense charged, the weight of the evidence proffered against the defendant, the characteristics of the defendant as he or she stands before the court, including his or her employment status, family ties, and length of residence in the community, the nature and seriousness of the danger that would be posed to other persons or the community if the defendant were released, and the risk that the defendant will obstruct the criminal justice process, and the public safety assessment recommendation. Now, in this case, the following facts are supported by probable cause. In 2021, the defendant was employed as an 8th grade teacher at a local middle school. At that time, the victim in this case would have been between 13 and 14 years old. The victim is a boy. He was a student in her 8th grade class. He has since reached the age of majority. On various occasions in 2021, the defendant did have sexual intercourse with the victim and also performed acts of fellatio upon him. At the time of the events, as alleged, the defendant was roughly 30 to 31 years old and had supervisory capacity over the alleged victim, who was then 13 to 14 years old, as I understand the facts as presented, and I found probable cause as to these facts. As a result of the investigation, which remains ongoing, the defendant was arrested and charged with second-degree official misconduct, contrary to 2C:30-2A, second-degree endangering, that being sexual contact with a child by a caretaker, and 6 counts of first-degree aggravated sexual assault where the victim is between the ages of 13 and 16 and whom the defendant had or has supervisory authority over, contrary to 2C:14-2A, 2B. While the charges against the defendant are significant and in the first and second degree, there remains a presumption in favor of release, which the state must rebut by clear and convincing evidence. I note this is not a case where the defendant is facing a life sentence and is not charged with murder, as to which the presumption would be detention. And therefore, in this case, the presumption is release on non-monetary conditions. That said, if the defendant is convicted on these very serious charges, given her current age, such a sentence could in all practicality constitute a life sentence. But it's not a life sentence as it stands today. The question then presented to this court is whether the state has proven by clear and convincing evidence that there are no conditions of pretrial release, which will ensure, number one, that the defendant appears for court as required. Number two, that will ensure the protection and safety of other people and the community. And 3, that the defendant will not obstruct or attempt to obstruct the criminal justice process. Now, as to the first prong, this defendant has never failed to appear for court and, in fact, has never been charged or adjudicated in any criminal case. And therefore, as to the first pillar of the Criminal Justice Reform Act, the defendant should be released. But the second and third prongs of this case is more nuanced. If this were simply a situation where a 5-year-old allegation is made and there is no physical or other evidence to corroborate the alleged sex acts, then it would be relatively easy analysis, given the defendant's lack of criminal history, to simply release her on non-monetary conditions. But the facts presented to this court, however, make this a more difficult analysis. The state alleges and defendant acknowledges that the state has collected over 7,000 pages of text messages between the alleged victim and the defendant, which bespeak an ongoing relationship, which, although not overtly physical, continued over the course of several years, even after the defendant had moved on to high school and then to the age of majority. The messages referred to have been described to the undersigned as sexting, including the distribution of various images, which, if ultimately recovered, could support the charge that the defendant was engaged in the manufacturing of child sex abuse material. Moreover, the victim has possessed nude photos of the defendant, which are in possession of him. Furthermore, the defendant has allegedly admitted in writing by text message her sexual involvement with the victim, and the various acts between them have been confirmed by her own admissions in writing. The state has a seemingly strong case where the testimony and/or statements of the victim are lined up with and confirmed by the content of the text messages between himself and the defendant. Turning then to the factors supporting a decision to detain the defendant, I have to consider the nature and circumstance of the offense charged, specifically 6 counts of first-degree aggravated sex assault against a minor by a supervisor, which has generally been corroborated by the over 7,000 pages of text messages between them. The particular circumstances include the fact that she was his teacher and he was an 8th grade student. Turning then to the weight of the evidence against the defendant, her own text messages constituted admissions as to the conduct which supports the first-degree sex assault charges as set forth. With regard to the history and characteristics of the defendant, it should be noted that the defendant does have strong community ties. She has no prior criminal record and has never failed to appear for court. And further, the defendant is not currently on any form of pretrial release, probation, or parole. Turning then to the nature and seriousness of the danger to the community, one must be cognizant that society generally has a need to protect teenage boys from predation by older adult women. And there is the potential for witness intimidation if the defendant is released. A person who has maintained and allegedly groomed a boy over a period of at least 5 years could have a substantial influence over him if perhaps she were to communicate with him primarily about the severity of the charges and the potential punishment. And finally, I've reviewed the release recommendation of the public safety assessment, which scores the defendant a 1 for failure to appear and a 1 for new criminal activity. But it does indicate that no release is recommended because of the nature of the near charge. That recommendation is contrary to State versus Mercedes. But given the weight of the evidence, both direct and circumstantial, in support of the charges in this case, and given the fact that there is a presumption of incarceration for a first-degree offense, this court finds that the state has proven by clear and convincing evidence that there are no conditions which will allow for the defendant's pretrial release in order to protect the public generally. In reaching this decision, the court is cognizant that the defendant was able to surreptitiously keep this relationship between herself and the victim private. That is, she hid the relationship from her husband, other people, and all others, and continued this relationship knowing his precise age. This is not a case where she did not use and utilize electronic means to hide evidence. It was presented clearly by the defense that the defendant has the ability to cover her tracks and has done so for a period of 5 years. Therefore, in analyzing all of the factors, I find the strength of the state's case is substantial. The offenses charged are significant, and the defendant must be detained. The defendant should have a reasonable opportunity for private consultation with her attorney. The defendant has been advised, and I'm now advising her, that she has the right to appeal this decision within 7 days pursuant to Rule 2:9-13. The defendant also needs to be advised of her next court date. I've also signed the SORO. I don't know if it's been transmitted to the jail for the defendant's signature, but given the decision to detain her in this case, I'm going to indicate that her next court appearance is a pre-indictment conference on May 14 at 9 a.m. before Judge Morgan. That matter will be here at the Gloucester County Justice Complex, and the defendant will be brought. Counsel, is there anything else to address?
Nothing from the state. Rocco, you're on mute.
You're muted, Mr. Ciparone.
Sorry, Your Honor. Thank you. Just to clarify, Judge, I think obviously this was just in an inadvertent misspeak. I think you said that it was presented by the defense that the defendant had the ability to cover her tracks. I'm just presuming you meant the state presented that. Of course, I did not present that she intended to cover her tracks.
The first time I went off script, yes, you're absolutely correct. The defendant has the ability and had the ability to cover her tracks and did so for a period of 5 years, which is why there is an obstruction element to this case. If I misspoke, I apologize.
I was just clarifying, Judge. I think you said that the defense that I presented that evidence, it was the state. Obviously, I did not present it.
You did not.
Thank you.
The state was pretty thorough in its presentation.
I appreciate that clarification, Your Honor. Thank you.
All right. Well, then we'll see you back at the pre-indictment conference on May 14. Best of luck to the defendant. Mr. Ciparone, have a nice day.
Thank you. You too, Your Honor.
We're going to shift now to Salem County, I think.
Judge, I'm sorry, can we go to Essex County?
Tatiana, I can't hear you for some reason.
Do you
I
hear me
kind
now?
of hear. Yes.
We have Essex County also logged in the booth. I'm just gonna go ahead and unmute. Give me a second.
All right, Tatiana, I don't know why. Maybe I'm not hearing well today.